Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. I must tell you to like, subscribe, comment down below. It helps me to help more people just like you and helps the channel to grow. We have a question here from Mind Over Matter today. I could have sworn I answered a question very similar to this recently, but maybe I didn't. Maybe I'm misremembering. I don't know. Here's the question. Question, is the fact that my employer tried to contest my unemployment and lost mean good things for a possible lawsuit? Should I show my determination letter to attorneys I contact to try to convince them I have a case? So, Mind Over Matter today, the question is, what is your lawsuit for? Like, what do you think the case is? If you're dealing with a workplace discrimination case, a workplace sexual harassment case, which is what we tend to deal with on this channel, then probably not that valuable, and I'll explain why. And I'll explain two caveats to that. So, in most of the U.S., as far as I'm aware, we deal with the language of for cause termination or not for cause termination, right? If you're fired, but it's not for cause, you didn't do something that gave your employer cause to fire you, generally that's when you qualify for unemployment benefits. If you resign or you do something horrible to get fired, generally you would not qualify. That would be a for cause termination or resignation, and you would not qualify for benefits. The elements to prove whether something is or is not for cause termination have almost nothing to do with the elements you need to prove to successfully prosecute a workplace sexual harassment or workplace discrimination case. The things you prove are not the same to win these different claims, right? So generally, and we'll go a little step further. Listen, the rules of evidence are super weird in unemployment hearings, super loose most of the time. The judges are little mini baby judges, administrative law judges. You know, it's not going to deem the same respect that other levels of judge might. And so there's not a lot of overlap. However, there are two situations that I can think of immediately where your unemployment hearing could be meaningful, and certainly this has come up in my practice over the years. First and foremost, if you believe you have a pretext for your termination, right? If your employer was like, oh, I got to fire this person because of their protected class. Like, I'll give you an example. Oh, they need accommodations in the workplace, so I'm going to come up with a pretext, a bullshit reason to fire them, and you then take that to the unemployment hearing and you dunk on your employer proving that that was not a real reason why you were terminated, that could certainly be valuable to your case, right? If you can prove a pretext in the unemployment hearing, real value. That matters. That can be useful. The second thing I'll say, when an unemployment hearing could be useful to your case, is when evidence comes up in the unemployment hearing that does happen to be useful in your workplace discrimination or workplace sexual harassment case, right? So like, if you're putting in evidence and there's like somebody testifying and the next line of questioning is like, oh, and then what happened next? And the answer is like, oh, bad actor dude A walked up to the benefits claimant and tried to physically molest her. Yeah, that might be really good for your sexual harassment case, right? Just to provide an example, context here, right? So in those situations, what you need to do is get the transcript or get the recording, whatever you can from that unemployment hearing, and use that evidence in your later civil case for workplace sexual harassment or workplace discrimination, right? So I'm not going to say the unemployment hearing is never meaningful. It absolutely can be. It's just usually not meaningful, and usually attorneys will tune you out when you start talking about your unemployment case, because there are so many people who don't understand that they don't understand at-will employment, right? And they think, oh my God, they didn't have a good reason to terminate me, so I'm going to sue. It's like, well, if you were at will, nobody cares. Unless the reason was motivated by some form of discrimination or sexual harassment or retaliation, right? And there's more. That's a simplified answer. But generally speaking, attorneys do have the really bad habit of tuning folks out who talk about their unemployment hearing, because we just deal with like 5-10 of those calls a day. And it's like, yeah, that's cool that you won your unemployment hearing. That's got nothing to do with a civil case, right? It takes digging and it takes explaining to really get that attorney to face the fact that like, oh, something meaningful did happen in that unemployment hearing, and it can help the civil case, and the civil case is stronger for it. So maybe I should pay attention to make an offer of representation here, right? You're going to have to be careful in how you couch that so that you don't just trigger that instinct in the employment attorney's mind to tune the F out. Because employment attorneys suck at listening to potential clients. Hopefully they're at least good with their actual clients. But in terms of potential clients, there is a low attention span all too often. Anyways, mind over matter today. I hope that helps. I wish you luck. Congratulations on your unemployment hearing. And I hope great things happen in your civil case. Everybody like, subscribe, comment down below. Helps me to help more people just like you. Like you.